the domain of possible agreements. In the case of passage through the Great Belt, which is the case of Finland versus Denmark, a 1991 case, the International Court of Justice concerning Denmark's construction of a bridge in the Great Belt, a strait between the Danish islands of Zealand and Funen, to which Finland argued to violate its right of free passage, the ICJ dismissed the case on account of an oral agreement between the Prime Ministers of Denmark and Finland resolving the conflict on their own. The negotiation and eventual oral agreement between the two leaders transpired over a mere telephone call. The International Court of Justice honored this agreement and dismissed the case. In another case in 1993, involving the legal status of Eastern Greenland, Denmark versus Norway, filed by Denmark against Norway, the International Court of Justice considered as binding the statements made on July 22, 1919 by Norway's Foreign Minister, Mr. Ilhem, in reply to Denmark's official query. Ilhem stated that Norway would respect the Danish sovereignty over Greenland. The court declared this statement as binding on the part of Norway, considering that a reply of this nature given by the Minister of Foreign Affairs on behalf of his government is in response to a request by the diplomatic representative of a foreign state. Informal agreements, such as oral agreements, are valid under international law because under certain situations, they are the most effective tools to reaching an accord between states. Informal international agreements are used to meet particular needs. They are chosen to allow governments to act quickly and quietly. States sometimes frame their agreements in informal terms to permit their frequent adjustment. For example, in the quota arrangements of the Organization of Petroleum Exporting Countries, or OPEC, the informal agreements permit rapid shifts in the response to rapidly changing market conditions relative to the supply of crude oil. Lastly, when security issues must be resolved quickly or quietly to avoid serious conflict, the less formal instruments will be chosen. If the terms are especially sensitive, perhaps because they would humiliate, embarrass one party, or convey unacceptable precedents, then the agreement itself may be hidden from view. For example, the deal to remove the missiles from Cuba during the Cuban Missile Crisis, the most dangerous crisis of the nuclear era, was crafted through an exchange of letters supplemented by oral promises initiated by then President John F. Kennedy through his emissary, then Attorney General Robert Kennedy, in dealing with Prime Minister Khrushchev. The Cuban Missile Crisis ended without firing a single shot. Hence, oral arguments are binding as long as it is clear from the language employed that there is an intention to be bound. In the Philippines, Mr. President, news agencies have reported through several articles that President Duterte had entered into an oral agreement with China during His Excellency's bilateral conference with President Xi Jinping in 2016. If indeed this was the case, President Duterte was well within his powers to do so. As chief architect of the nation's foreign policy, the President can enter into executive agreements with other nations for the execution and implementation of the laws crafted by Congress, as well as treaties entered into by our country. These executive agreements, with due respect, do not require Senate concurrence. As explained in the landmark case of Sagisag versus Ochoa, decided January 12, 2016, the case that ruled that the Enhanced Defense Cooperation Agreement with the United States is a mere executive agreement if an international agreement is traceable to an express or implied authorization under the Constitution, statutes, or if they involve the implementation of existing policies, laws, or agreements, or if they are just concluded to adjust details of a treaty pursuant to an act of the legislature, or if it is simply an exercise of the President's independent powers under the Constitution, then the agreement is a mere executive agreement that does not require the Senate's concurrence. In the previously mentioned case, even Justice Antonio Carpio wrote in his separate concurring opinion that the implementation of the Mutual Defense Treaty is a purely executive function since the Senate has already ratified it. And as the chief architect of the country's relations with foreign countries, the President is constitutionally vested with ample discretion in the implementation of the MDT, or the Mutual Defense Treaty. In other words, Mr. President, this humble representation submits that there is no need for this honorable body to concur to the alleged oral agreement between President Duterte and President Xi Jinping, because it is merely in implementation of the provisions of UNCLOS, and secondly, an implementation of other treaties such as the Straddling Fish Tax and Highly Migratory Tax Agreement, the Food and Agricultural Organization Code of Responsible Fisheries, among others, which I will expound later on. Mutual respect for the three branches of government must be maintained by avoiding interference or deciding on matters involving political questions which fall within the exclusive authority and competence of the President. The conduct of foreign relations is full of complexities and consequences, sometimes with life and death significance to the nation, especially in times of war. It can only be entrusted to the Department of Government, which can act on the basis of the best available information and can act swiftly. It should be entrusted to someone who possesses the most comprehensive and the most confidential information about foreign countries and who has also unlimited access to ultra-sensitive military intelligence data. In our case, the President of the Republic of the Philippines. Mr. President, I rise likewise on behalf of our Filipino fishermen who are struggling to make a living in the West Philippine Sea. Proceeding to my second point, there is a need to protect the rights and safety of Filipino fishermen and secure for them the benefits of peaceful utilization of available marine resources. It is a fact that a significant number of Filipinos rely on our seas as a source of livelihood. In order to protect the marine resources vital to this industry, the country has entered into various international agreements, all aimed at the conservation of our seas and the management and utilization of its resources. One of these agreements is the United Nations Convention on the Law of the Sea, or UNCLOS. This convention has granted the country numerous rights for the attainment of economic stability, as well as obligations for environmental conservation and international peace. Among these obligations is the mandate to cooperate with other states in the protection and utilization of our exclusive economic zone, or the EEZ. Historically, Mr. President, the EEZ, formerly known as the Exclusive Fishing Zone, is defined as an area beyond and adjacent to the territorial sea, which shall not extend beyond 200 nautical miles from the baselines. This was first introduced by the Western states in the 1940s. In 1947, Peru and Chile unilaterally proclaimed a 200 nautical miles EEZ, while in 1952, Peru and Chile entered into a treaty called the 1952 Santiago Declaration, with the objective and purpose of a coordinated conservation and protection of the natural resources in the parties' extended maritime zone. On the other hand, following what has already developed into customary international law, the Philippines declared its own EEZ to Presidential Decree 1599 in the year 1978. The 1987 Constitution also contains a provision on EEZ as part of the section on national patrimony and economy, as it provides in Article 12, Section 2, Paragraph 2 thereof, and I quote, that the state shall protect the nation's marine wealth in its archipelagic waters, territorial sea, and exclusive economic zone, and reserve its use and enjoyment exclusively to Filipino citizens. The term EEZ in our Constitution was adopted from the UNCLOS itself. This can be readily seen from the very deliberations that proclaim the provisions and the fact that it was in existence in the 1935 and the 1973 constitutions. The UNCLOS, the convention that granted us sovereign rights, not sovereignty over the sea, provides for and promotes the spirit of cooperation among states, from the provisions of sharing the surplus of allowable catch in the EEZ to managing straddling fish stocks and highly migratory species, and to sharing with landlocked and geographically disadvantaged states under Articles 69 and 70, the UNCLOS urges, nay compels the states to cooperate with each other for the preservation and utilization of our oceans and seas. The spirit of the convention has been befittingly espoused by the Constitution, our Constitution, that adopted its terms. Looking into the minds of the commissioners that crafted the Philippine Constitution, it is indisputable from the records on August 25, 1986, that as proposed by former Chief Justice Roberto Concepcion and as adopted by the committee, it was intended that the word exclusive economic zone in the cited provision would refer only to the exploitation of the seabed and the waters above that portion form part of the high seas and are subject to the general principles of international law. General principles of international law, as referred to by the former Chief Justice Concepcion, are universally accepted principles fundamental to all legal systems and recognized by civilized nations. One of which is Pacta non servanda, which dictates that international agreements which are legally binding must be performed in good faith. Following this principle, the country is mandated to ensure that it honors its commitments in the international arena concerning treaties that it has validly entered into regardless of form. Justice Isagani Cruz, in his book on international law, says that the country must always strive to perform its obligation in good faith, despite the hardships such as conflicts with the Constitution, domestic law, or national interest. This principle is emphasized in the Vienna Convention on the Law of Treaties, and I quote Articles 26 and 27 thereof, which provides, every treaty in force is binding upon the parties to it and must be performed by them in good faith, and that a party may not invoke the provisions of its internal law as a justification for its failure to perform a treaty, unquote. An international arbitration case, Mr. President, to cite one, worth noting, is the Alabama Claims Arbitration case decided in 1872, wherein the British were ordered to pay the United States for breaching their agreement of neutrality by failing to stop the construction of warships in their country that were used in the U.S. war. The arbitrator in that case rejected United Kingdom's excuse that they only breached the treaty because of the insufficiency of legal means available to them under their domestic law. The Philippines then must honor its commitments to the international community, especially concerning cooperation between states in the conservation and protection of our marine resources. In the words of former Chief Justice Artemio Panganiban, in the case of Tañada versus Angara, May 2, 1997. I quote, "The Constitution did not envision a hermit-type isolation of the country from the rest of the world. The Constitution did not intend to pursue an isolationist policy," unquote. Russia and Norway, through the Barents Sea fisheries regime, have decided to grant mutual access to their respective EEZs in the light of their shared fish stocks and fishing grounds. Through their collaboration, both countries have established an effective fisheries management system without jeopardizing the competing claims of sovereignty over the sea. Their bilateral agreement has facilitated in scientific research and has improved compliance control over the area to prevent illegal, unregulated, and unauthorized fishing. In the Pacific, Mr. President, countries such as the Federated States of Micronesia, with Kiribati, the Marshall Islands, Papua New Guinea. Papua New Guinea is a classic example, having granted 29 fishing rights to Filipino fishing companies. Solomon Islands, among other states, have all realized their need and the benefits of working together. These countries have established a multilateral fisheries management agreement in order to more effectively utilize and manage their shared resources. Other Pacific countries such as Cook Islands, Fiji, Gilbert Islands, Nauru, New Zealand, Tonga, Tuvalu, and Western Samoa all share in the sentiment that the best and only way forward to a more ecological and economically feasible fisheries regime is through international cooperation. The United States of America and Canada in the management of the Pacific salmon, Angola, Namibia, and South Africa in the management of fishery resources in the Benguela large marine ecosystem, and near us, New Zealand and Australia in the management of the South Tasmanian rice and more. The list goes on to include more countries that have made this realization. As a matter of fact, a 2016 study by the World Bank shows that around half of the world's exclusive economic zones are subject to some form of foreign fishing arrangements, be it through access agreements, joint ventures, or even just chartering. The benefits of international cooperation, when properly executed, are limitless. Another case in point is Morocco, who receives access fees from the European Union countries to fish within its EEZ. Study shows that 75% of the socio-economic impact of their agreement is for the benefit of Moroccans. Another international commitment the country must honor, with due respect, Mr. President, is the Food and Agriculture Organization, or FAO. On October 16, 1945, the Philippines joined the Food and Agricultural Organization, a specialized agency of the United Nations that leads, among other members of the international community, with the goal of achieving food security by creating and sharing critical information about food, agriculture, and natural resources, and by transporting the transition to sustainable agriculture. Towards this end, the regional fisheries bodies around the world was created, and one of which, a neglected organization called Asia Pacific Fishery Commission, that was organized in 1949 in Baguio City, Northern Luzon. The Asia Pacific Fishery Commission is an advisory body and coordinating mechanism composed of several states, including China, Australia, Bangladesh, the Philippines, France, India, Indonesia, New Zealand, among others. They work together, they should work together, they were envisioned to work together towards the conservation and management of fisheries to promote a fully sustainable utilization of aquatic resources through policies and practices, including finding solutions to regional issues that affect the member states. However, the disputes in the West Philippine Sea caused by overlapping claims of exclusive economic zones have been a continuing hindrance to achieving the aims of the Commission. As a result, no institution concerning fisheries has been established to monitor and manage the resources of the West Philippine Sea. The states fishing in the area, including the Philippines, continuously fails or does not accurately report its catch to the FAO or the APFIC, while BIFAR, or the Bureau of Fisheries and Aquatic Resources of the Department of Agriculture, has set a catch ceiling limitation for tuna. The Philippines has not set allowable catch ceilings and has no data regarding the optimal catch in its EEZ. The last data reported, as per my research, was 2012. The failure to set these standards and to report information regarding the resources in the West Philippine Sea is detrimental to the conservation and management of the area. The conservation of the reefs in the West Philippine Sea is critical to the supply of marine resources, not just to the Philippines, but to the whole world. In order to achieve this goal of conservation, management, and full sustainability, cooperation and coordination with our ASEAN neighbors is imperative. As a signatory to international agreements, including the 1995 Agreement for the implementation of the provision of UNCLOS relating to the conservation and management of straddling fish and highly migratory fish stocks, which the country ratified on September 24, 2014, the Philippines is bound to pursue cooperation through bilateral, sub-regional, and regional fisheries arrangements to avoid overfishing, promote responsible fishing, conserve the biodiversity of aquatic habitats and ecosystems, and protect endangered species and restore depleted stocks. Though running late, the Philippines has made the initial steps for this endeavor. Last June 3, 2019, this August Chamber has given its concurrence to the Philippines-Indonesia EEZ delimitation agreement that the country has ratified on February 15, 2017. This is a major step as the resolution of this dispute through peaceful means will be the start of a possible future joint cooperative endeavors with Indonesia in managing our very close and adjacent waters. As we strengthen ties with other Asian nations who share in the abundant resources of the West Philippine Sea, we take advantage of cooperation through access to scientific, eco-marine data, as well as the protection of our resources from illegal, unregulated, and unauthorized fishing. The journey towards sustainable development is still long and winding. The seas to be traversed are rough, but what is important is that the country keeps on sailing. Having emphasized, Mr. President, the need to honor our commitments to the international community, it behooves upon us, distinguished members of the Senate, to rise up to the challenge of navigating through the uncharted realm of international law in order to protect our resources and uphold the rights of every Filipino. While cooperation with the international community is important, the welfare and benefit of the Filipino people should always be a priority. Of all the country's resources, it is the people that is most treasured, protected, and must be served. Hence, Mr. President, may the 18th Congress endeavor to enact more meaningful legislation to fortify, defend, and uphold the rights and satisfy our obligations for the benefit of our countrymen as well as our dignity. Taking cue from other nations that have found it essential to protect their resources and uphold their people's rights, may the 18th Congress enact similar legislation, such as the United States Outer Continental Shelf Lands Act, among others, wherein the United States has declared that their constitution, civil and political laws, as well as criminal and federal regulatory laws, are extended and applicable to their subsoil, seabed, and all artificial islands and all other installations attached thereon. The protection and safety of our people require our foresight in drafting laws as we tread towards further utilization of both living and non-living resources in our sea. This humble representation, Mr. President, calls on this chamber's support in the passage of these representations proposed Senate Bill 209, the Good Samaritan at Sea Law, that aims to implement the provisions of the International Convention for the Safety of Life at Sea. With this law, Filipino fishermen will be afforded additional safety as they pursue their way of life. This representation has likewise filed proposed Senate Resolution number 12, or the resolution in support of the prohibition of fisheries subsidies in the World Trade Organization, to lessen the perceived disadvantage of Filipino fishermen against foreign entities and to protect the resources in the EEZ against illegal, unreported, unregulated, or IUU fishing, overcapacity, and overfishing. Fishing subsidies that contribute to these problems must be eradicated internationally. The United Nations Conference on Trade and Sustainable Development Goal Target 14.6 targets that by 2020, the United Nations member states should prohibit certain forms of fisheries subsidies that contribute to the aforementioned problems and refrain from introducing new subsidies by 2020. The realization of this goal would level the playing field for the Filipino fishermen, as they will be able to perform at the same level as their foreign counterparts. Resources will be more equitably exploited and protected from overutilization while enhancing the lives of the Filipinos. The need to stay true to our international commitments is not just to maintain our international standing, Mr. President, but most importantly, in order to uphold the rights and dignity of our people and protect the nation's honor. This humble representation wishes to end this speech with the words of Gat Andres Bonifacio in his work, Ang Dapat Mabatid ng mga Tagalog, circa 1896. And I quote, "Kaya o mga kababayan, ating idilat ang bulag na kaisipan at kusang igugol sa kagalingan ng ating lakas, sa tunay at lubos na pag-asa na magtatagumpay sa nilalayong kaginhawaan ng ating bayang tinubuan." Thank you, Mr. President. I yield the floor.
The minority leader is recognized. Before we recognize Senator Pia Cayetano.
Thank you, Mr. President. Just for the record, will you gentlemen yield the floor to a few questions?
Willingly to the senior and most erudite minority leader, Mr. President.
Thank you very much, Mr. President. Mr. President, first of all, let me spread into the record our commendation for the gentleman from Cavite for raising and placing on record such an important and critical issue that the nation faces not only today, but in the future, both in terms of the welfare of our people and the fate of our nation. And this is the issue which involves the West Philippine Sea and the provisions of the Constitution, which explicitly mandates the protection of our national resources. But let me start this period of interpretation with a request for clarification. We heard the gentleman very clearly on the arguments that he raised on the issue of the agreement between the President and President Xi Jinping of China. But our first question, Mr. President, is can the gentleman spread into the record exactly what the verbal agreement is between the two presidents? Because other than the media reports, I don't think anyone has a record of what the agreement was. Will the gentleman be kind enough to spread this into the record, if he knows?
Mr. President, as what I stated in my speech, the basis of my proposition was related to several anecdotal reports that apparently there was a verbal agreement 2016. I'm not exactly sure of the month, wherein the President allowed Chinese entities to fish within the West Philippine Sea. But I don't exactly, Mr. President, since it's an oral agreement, I don't have any records of the product of that salivatic agreement, Mr. President.
So if we do not know exactly the parameters of the oral agreement, how can we say that this is valid under international law, that is valid under our Constitution, when we do not even know the parameters of this agreement? So before we get into a debate, and what exactly are we debating on?
My premise, Mr. President, is that there have been calls, even from an incumbent, a sitting justice of the Supreme Court, that said oral agreement would require the concurrence of the Senate.
That is why, yes, we heard that. That is why we did not pick it up, Mr. President, because we did not know what exactly to ratify or what exactly to revoke, because we do not know the agreement, the parameters of the agreement. So I think it is incumbent upon the gentleman from Cavite, who so wisely and judiciously brought this issue on the floor of the Senate, to first tell us what the President exactly agreed upon, so that we can debate. For one, is it a valid agreement under our Constitution? Number two, can we ratify this? Or or should we leave it at that because we do not know exactly how it stands? So I think unless we have on the record exactly what this agreement are, it's difficult to debate. Given the access of the gentleman from Cavite to the President, is it too much to ask for the gentleman to ask the office of the President to inform him, at least officially, of what the agreement is all about, so that we have something in writing to rely upon in our debates?
Mr. President, may I refer the distinguished gentleman from Iloilo that there was an instance wherein a similar issue was laid before the Senate concerning the availability of an agreement, and a decision coming from the Supreme Court. If I'm not mistaken, Pimentel versus Executive Secretary, the Supreme Court clearly stated that no governmental entity can force the executive, the office of the President, to produce a treaty for ratification. I'm referring during those days to the Treaty of Rome. It was part of the decision of the Supreme Court that the chief executive cannot be compelled to produce the treaty, much more for an oral or verbal, informal agreement, which is not in writing, but the effectivity of which I have laid down in my speech as needed, not just for commerce, but in terms of national security.
With all due respect to the gentleman from Cavite, if our memory serves us right, the issue in the Rome Statute was whether or not the President can be compelled to submit to the Senate for concurrence the Rome Treaty. The first step in a treaty ratification is for the President to ratify. And after ratification, the ratification is referred to the Senate for concurrence. We are not ratifying the treaty. It is the President who ratifies the treaty, and the Senate concurs in the ratification. That is when the treaty becomes effective. In the particular case of the Rome Statute, then the previous president then did not want to ratify the Rome Statute. And therefore, without the ratification of the Rome Statute, there was nothing for the Senate to concur. Now, the Supreme Court correctly said, you cannot compel the president to ratify a particular treaty. That is a prerogative of the president as the chief architect of foreign policy. If and since the president did not ratify, the Senate had nothing to concur in. It is completely different in this case, Mr. President, because there is an asserted agreement, and this agreement is entered by no less than the president himself, albeit verbally. And since it is now on the floor and up for debate, I think the basis of the debate, at the very least, should be a definition of the parameters of this agreement. What is the agreement all about? At least we should know, we will have a basis as to whether or not it is consistent with the Constitution, as to whether or not it can be ratified, and whatever. The Senate, as the partner of foreign policy in the structure of government, the partner of the executive, at least will be able to exercise his judgment. And I congratulate and commend the gentleman from Cavite for asserting that this is within the jurisdiction and the jurisdiction of the Senate in terms at least of the examination of the parameters of the power of the president. The gentleman said this is binding. Question, what are we being bound to if we do not know what the agreement is? The gentleman said oral agreements are valid under international law. What is this oral agreement? What is the basis of our judgment that it is valid under international law, when in fact we do not know what the agreement is all about? So I think for us to have a judicious debate on this issue, and again, I commend the gentleman from Cavite for bringing this on the floor, for availing of the privilege hour in order to have a healthy debate on this. That because indeed the nation is entitled to know, and the gentleman is indeed fulfilling his duty as an elected representative of the people to bring this on the floor so that the people can be clarified as to what this agreement is all about. And I will repeat for the last time, what is the agreement that is binding on our country according to the good gentleman from Cavite?
Mr. President, for the end time, allow me to recast the propositions I laid down a while ago. One, if there was indeed an oral agreement, according to anecdotal news reports, that oral agreement would not need the concurrence of the Senate. That's what I mentioned, Mr. President. Reason number one is that that oral agreement is similar to the EDCA Supreme Court decision, which is part of the Mutual Defense Treaty concurred in by the Senate in 1952. The reason being is that the oral agreement, if there is indeed an oral agreement, is just part or an implementation of UNCLOS, which we ratified. So the mother agreement is UNCLOS. The oral agreement implements UNCLOS in the same manner as the EDCA implements the Mutual Defense Treaty, which has been upheld by the Supreme Court. But having said that, Mr. President, I think part of my speech would be the challenge to this august body to craft the needed legislation so that confronted with issues, similar issues such as this in the future, we may be able to draw the lines in pursuit of the concurrence power of the Senate. To be very clear, Mr. President, in the United States, there is Public Law 92403, if I may place this on the record, which would require the Secretary of State to transmit to Congress any oral agreement or even a summary thereof for scrutiny of the United States Senate. That is my point, Mr. President, when I ended my speech, that there is a lot of uncharted waters to be navigated by this august body, Mr. President.
Mr. President, the good gentleman from Cavite cited the EDCA to support the proposition that the Duterte-Xi Jinping agreement does not need concurrence of the Senate. First question, would the gentleman agree that at least in EDCA we know what the agreement is all about?
I agree, Mr. President.
And therefore, on the basis of that knowledge of what the agreement was all about, the Supreme Court said it does not need the concurrence of the Senate because it is only in implementation of the Mutual Defense Treaty. Do you agree, Mr. President?
I agree, Mr. President.
Now, but in this particular case, since we do not know what the agreement is, how can we come to the conclusion that it does not require the concurrence of the Senate when in the first place we do not know what the agreement is all about, Mr. President?
That is precisely my point, Mr. President. Since this is an oral agreement, we do not know the parameters, we do not know the metes and bounds, we do not know the contents. We rely on the political judgment, good faith decision of the President to fulfill his duty on what is good for the country, as stated in the case I cited a while ago, the Angara case, wherein the Supreme Court stated that it will not dwell, it will not put into scrutiny the wisdom, the judgment of the Chief Executive in entering into the World Trade Organization agreement several years ago, Mr. President.
Would the gentleman agree that any agreement, written or otherwise, must conform with the Constitution?
Yes, Mr. President.
Now, having said that, Mr. President, is it not logical that we know what the agreement is all about in order that we can judge as to whether this agreement is consistent with or contrary to the Constitution?
I agree, Mr. President.
If you agree with that, Mr. President, if you agree with that, Mr. President, is it not logical that we place on the record officially what is the agreement and the parameters of the agreement between the two heads of state in 2015 or 2016? Is it not incumbent?
Mr. President, I do not have in my possession the content of the alleged verbal agreement, but from the context of my speech, the difference between a verbal, informal treaty is that, and a treaty concurred in by the Senate, is that a verbal, informal treaty is of short-term duration, and in implementation of a bigger treaty to answer the exigencies of the times, Mr. President. That's why in my speech I mentioned, Mr. President, to refresh the memory of our colleagues, the instance concerning the Cuban Missile Crisis. If they needed a U.S. Senate ratification, negotiations, probably it would have resulted into World War III. Kung mag-uusap pa ho na matagal. Kaya ang nangyari po doon, verbal oral agreement, inutusan yung Attorney General, tapusin na natin to para matahimik na yung hemisphere na binanggit ko kanina. So meron po mga pagkakataon, mahal na Pangulo, na hindi po kailangan dumaan sa isang mitikuloso, na pamamaraan kung saan bubusisiin ang lahat ng nilalaman. Pero naniniwala po ako, ang ating Pangulo, na ginagawa po ang kanyang tungkulin sa ilalim ng saligang batas, ay hindi naman po gagawa o papasok sa isang kasunduan na makakasira sa ating bansa. Yun po yung ibig ko po sabihin, mahal na Pangulo.
Thank you, Mr. President. Indeed, nobody is casting aspersion on the aspiration of the President to protect the Filipino people. What we are just looking at here is precisely what is this agreement, and if indeed it promotes national interest, it is consistent with the Constitution and our international obligations, we will be the first to say, to support such proposition. But unless we have at least a reference point on what the agreement is all about, nobody knows whether or not this agreement is contrary to or consistent with the Constitution. It is in that aspect and context, Mr. President, that we are pleading with the gentleman to help us and help this institution perform its task by spreading into the record what this agreement is all about. Because after that, we can debate on the effects of a verbal agreement, and we can debate as to whether this verbal agreement is binding. We can assert as to whether, we can debate as to whether or not it needs the concurrence of the Senate. But until we know what the agreement is, we'll never be able to answer that question. All of us here are relying on media reports, including this representation, and I'm sure including the President of the Senate. But now that this matter is brought before the floor, this is an opportunity for us to have an official reference of the act of the President, and not merely based the same on media reports. As a lawyer of note, Mr. President, the gentleman from Cavite will agree with us that until we have a definite pronouncement, or at least record in the Senate, of what this agreement is all about, it is extremely difficult to debate on the issue and come up with the proper policy formulation. That is our submission, Mr. President.
I concur with the gentleman from Iloilo, Mr. President.
If thank you, Mr. President. If the gentleman will concur, can we have the agreement stated on the record?
As I have mentioned, Mr. President, I don't have in my possession, nor do I have the capacity to secure agreements coming from mere saliva. I think the proper agency that would have to report here would be the Department of Foreign Affairs. If there is indeed such an agreement, considering they are the official repository of all treaties and international agreements entered into by our country.
I note that the gentleman raised the question if indeed there is an agreement. Are we now not certain that there is an agreement? The gentleman just said the DFA is the repository of knowledge and information. If indeed there is an agreement, are we now doubting the existence of the agreement, Mr. President?
Mr. President, as I mentioned several times, I am not in possession of the agreement, but consequent events after the alleged closure of the Scarborough Shoal led to the opening of the same area for Filipino fishermen. And the recent incident of June 9, 2019, concerning the collision incident of the vessel from Mindoro would show that some Chinese vessels are indeed present in our exclusive economic zone. And we have heard the Secretary of Foreign Affairs that such accommodation was by virtue of an agreement relative to the sharing, quote-unquote, provision allowed under UNCLOS. I have no possession, Mr. President, of any transcript or verbal agreement, and I agree with the gentleman from Iloilo that we don't have a copy of that. I was expecting that that would be the salient points of the State of the Nation address, but that was not the case. But be that as it may, what this representation raised a while ago would serve as our guideposts for future incidents, for future administrations, wherein the power of the Senate to concur would be put into question. What I'm saying, Mr. President, is that it is now time that we craft into law a legislation that would require the Department of Foreign Affairs to place it in black and white, all agreements, whether informal, formal, verbal, oral, implied, or what have you, into in writing, so as to comply with the Vienna Convention on the Law and Treaties, which would require that all agreements be placed in writing, Mr. President.
So, do I understand it, Mr. President, that the gentleman is calling upon the Department of Foreign Affairs to put in writing the verbal agreement between the President of China and our President? From that statement that the gentleman just made, must now the DFA put it in writing?
I never mentioned that, Mr. President. What I mentioned a while ago, for the information of the gentleman from Iloilo, is that in the United States, they have a law. I mentioned a while ago, PL number 92, PL number 92403, requiring the Secretary of State to transmit to Congress any verbal agreement to which the United States is a party as soon as practicable, and I quote, after such an agreement has been entered into. What I'm saying, Mr. President, is probably there might be a gap in our current books concerning oral agreements. And to refresh again, the good gentleman from Iloilo, I'm sure he's familiar with this. The reason why secret agreements are banned is because during the Hitler-Stalin days, they have a secret agreement concerning the invasion of Poland and other European countries. So they crafted a law, they crafted a treaty requiring oral agreements to be placed in writing. But there are instances that would really require swift executive action, not necessitating the usual rigorous negotiations in the treaty-making process that would likewise require the lengthy deliberations in a body such as this, Mr. President. So I'm not saying that the DFA is required. What I'm saying is that we need to have a law put in place requiring for future reference that any oral agreement be placed in writing.
Now, this privilege speech, I assume, Mr. President, will be referred to the Committee on Foreign Relations. Can the chair of the Committee on Foreign Relations, the Honorable Pimentel, now issue a subpoena to the Department of Foreign Affairs, requiring the Department of Foreign Affairs to come before the committee and testify under oath what this agreement is all about?
Mr. President, I'm not at liberty to speak on behalf of the good senator from Cagayan de Oro. If this will be referred to the Senate Foreign Relations Committee,
On the basis of my little knowledge, after 21 years of being in the Senate, my little knowledge of the rules of the Senate and the jurisdiction of the committee, I have no doubt that this will be referred to the Committee on Foreign Relations, headed by our good colleague, Senator Pimentel. So I just assuming that this is true, or for that matter, assuming that we do not even have to cite Senator Pimentel, but can the chair of the Foreign Relations Committee subpoena the Secretary of Foreign Affairs and require him to put under oath and into the record of the Senate this verbal agreement between President Duterte and the President of China under the theory of the good gentleman from Cavite?
Mr. President, I assume that if ever this will be referred to the Senate Committee on Foreign Relations, in the exercise of its committee powers, I think the chair would accede to the suggestion of the good senator from Iloilo that that the Committee on Foreign Relations subpoena the good Secretary of the Department of Foreign Affairs.
Yes, and would the gentleman, however, agree that in order that we can have a matter that we can discuss substantially and in substance, we must have the verbal agreement put into scrutiny by putting the same in the record of the Senate, at least to the Committee on Foreign Relations.
Just, Mr. President, just to repeat again my answer a while ago, there is no existing law requiring that verbal, oral, implied, informal agreements be placed in writing.
There may be no existing law, Mr. President, but the power of Congress and its committees to issue a subpoena is within the power, is in the Constitution, and this is a legitimate congressional inquiry brought up by no less than gentleman from Cavite himself, and therefore an inquiry is perfectly within the bounds of the powers of Congress, and the power to subpoena the Department of Foreign Affairs does not need an enabling law. That is an inherent power of Congress as sustained in a number of decisions for Congress to exercise, and failure to comply will expose the witnesses to contempt and deprivation of liberty, as Senator Gordon has so rightfully jailed a number of people for refusing to heed a subpoena of the Senate. And therefore, the power of the Congress to compel the Department of Foreign Affairs to come to the Senate and testify on this alleged agreement needs no legislation, with all due respect to the gentleman from Cavite.
The two gentlemen will allow. Senator Coco Pimentel is recognized.
Yes, thank you, Mr. President. With the permission of the two gentlemen, since the Committee on Foreign Relations was mentioned in anticipation of the referral of the privileged speech as well as the interpellation to the committee, for the information of everybody, we will constitute now the committee. I have complete. I will be submitting.
Mr. President, at a certain point that is proper.
Yes, I will be submitting it now.
Period of interpolating on the speech. I think the matter of organizing the Committee on Foreign Relations can come afterwards.
Yes,
there is no harm in having it after the speech.
I'm informing Mr. President that the committee will be fully constituted. Then we will wait for the referral. Then we will hear this on the subject matter, which is actually the need. From what I get, this is actually on the need. On the need to enact a law to govern verbal agreements. But then the example used was the agreement between the verbal agreement between President Duterte and President Xi Jinping. So, and then we will follow procedure that we do not, as I understand Senate rules, we do not go directly to issuance of subpoena.
We did not. We were just citing the power of the committee in response to the need or to the assertion that we need a law to require the production of such agreement. What we're saying is under the powers to issue subpoena, that kind of an agreement can be brought before the Senate and debated and produced because of the inherent power of Congress to issue subpoenas. We do not need a law about that, on that.
Yes, Mr. President, the hearing will precisely, with the cooperation of the executive branch, the hearing will now shed light on the executive department's position on the nature of the agreement.
Yes.
Yes, so if
that's
the
correct.
if from the
on
point
the
of
nature
view,
of the agreement,
yes.
How can we determine the nature of the agreement when we don't even know what the agreement is all about?
That's why.
That is why the first question is the gentleman now taking over the floor and answering all the questions on the period
No, no.
of interpretation.
So I will end. I will.
The last time I heard, it is the gentleman from Cavite who had the floor and he
So,
yielded it to this representative.
I just intervened, Mr. President, with the permission. So I will end my intervention, but I want to inform my colleagues and the Filipino people that I just met this morning with the chairman of the Committee on External Relations of the Communist Party of Vietnam. And I extended our thanks on behalf of the Filipino people to the Vietnamese people for saving our countrymen who were in distress at sea when they were abandoned after the ramming incident, Mr. President. Thank you very much.
Thank you. That's a very noble act on the part of the putative chair of the Committee on Foreign Relations. Thank you very much. So can we go back to...
Yes, the Minority Leader has the floor together with the Senator Tolentino.
I already forgot what my last question was, if there was any. But in any case, Mr. President, I don't want the...
The chair is just curious. We would like to pick the mind of the distinguished gentleman from Iloilo. What are the list of treaties or what have you that are submitted to the Senate based on the Constitution?
To answer that question, Mr. President, we must know what the agreement is all about.
Yes.
In my view, Mr. President, if the agreement seeks to change certain domestic laws, then you need the concurrence, ratification of the President and concurrence by the Senate. For example, tax treaties, where you exempt from our income tax earnings of foreigners in our country through a tax treaty, that would require an agreement. Where the government under that agreement is bound to do certain acts, then you have to or adherence to certain policies. Then that is a treaty which needs the ratification of which would need the concurrence of the Senate. And in answer to your question, Mr. President, there is no fixed rule. We must determine on a case-to-case basis whether a document or an agreement is an executive agreement or a treaty that requires ratification. But the first issue is before we can determine whether the document imposes an obligation or is merely an executive agreement, we must know the agreement. Hanggang ngayon po, hindi natin alam kung ano agreement.
Like you, Your Honor, we would like the definition of agreement as far as that verbal agreement is concerned, because we're supposed to ratify conventions, treaties, and agreements.
Yes. So,
how do we define agreement in this case?
There is no, as I said, in my view as a lawyer, it's on a case-to-case basis. You must look at each agreement. There is no fixed rule. I can only think of general rules like if the agreement changes certain domestic laws, then you must ratify. But as I said, I will repeat, it depends on a case-to-case basis what the agreement provides, because you have to determine what is incumbent or what is obligated, what is the obligation of the parties under the agreement. That is why we must know what the agreement is all about, Mr. President, in order to determine whether it is simply an agreement, international agreement, which does not need ratification of the Senate. For example, Mr. President, cultural exchanges where you exchange dance troops, yung mga sumasayaw, ipadala mo sa Russia o ipadala mo kung saan. Hindi po sa akin, hindi po kailangan ng ratification po yan. Dahil hindi naman kailangan ang mananayaw ay dadaan dito sa Kongreso. So, as I said, Mr. President, it depends on what the agreement is all about. But because in my view, there is no one rule that we can cite. But to determine that, we must know, we must have on the record what is the agreement. I don't think we can divine whether or not it is an international agreement, a treaty, or what have you, unless we know what the agreement is all about. So it is in that sense. But anyway, Mr. President, I still have a number of questions.
All right.
Yeah, we will suspend our period of interpretations. We can come back on another day to ask the questions before it's the referral of the speech to the appropriate committee.
Before we refer it?
Yes.
All right. Then we'd like to recognize now Senator Pia Cayetano, who was earlier raising her hand.
Thank you, Mr. President. Very briefly,